Hi, my name is Katina Michael. I'm from Arizona State University, and I'm here with Dr. David Kolevski from the University of Wollongong. Hi, David.
Good afternoon.
It's great. We've got another paper coming out, this one again on cloud computing and stemming from researching your thesis.
Yes, definitely. It's a part of the thesis where it was a bit more challenging, but it was definitely more worthwhile now. Looking at the legal implications, especially towards cloud data breaches. And it was an interesting and fascinating area of investigation. That's for sure. Yeah.
Well, we all decided, along with Dr. Robert Abbas and Dr. Mark Freeman, to submit the work to the IEEE Norbert Wiener Conference. And Norbert Wiener, the renowned mathematician from MIT, who really brought us a lot to do with cybernetic theory. He was the father of cybernetics. But he was also an advocate for issues to do with, I think, tech for good and also fairness. A lot of his autobiographical work and his books pointed to this. He loved innovation. He really was like the person who considered the feedback loop as being an integral part of information science. But he also said, what about the citizens? Very interestingly, he was, asked to participate in World War II using his intellect for harm. And he just cried out, it's no good to use tech for harm. And so we thought we would submit this paper on cloud data breach disclosures, specifically focused with the consumer and the disclosure of their personally identifiable information to the Norbert Wiener Conference. And it went through quite a few reviews. We were a bit surprised, but we thank Professor Gopal Tadepalli from Anna University in Chennai for that whole review process as program chair. It was brilliant, and we learned a lot from the process, and we know the paper's really strengthened. So thank you for your massive contribution to cloud computing data breaches, David. With that introduction, I'd love you to share your presentation, the one that you just showed at the Norbert Wiener Conference.
Most definitely will, Katina.
And I'll just enable your screen sharing, David. You should be right to go.
Awesome. Well, first I want to thank all of my co-authors, including you, Katina, for the awesome input, feedback, and the countless revisions in order to get this conference paper successfully submitted. And I too would want to thank the Norbert Wiener committee members. Okay, so before I present my presentation, I would like to just give a brief rundown of myself. I'm a recent PhD graduate from the University of Wollongong, and my thesis investigated cloud computing data breaches, specifically looking at the social, technical, as well as legal implications. And this research is just a subset of that. So now, before we go into the presentation, the overview would be a brief introduction in cloud computing data breaches, a background to the state of play, literature review going through recent studies that have also investigated the data breaches as well as cloud computing hacks, the methodology applied in this study, the various case studies that I've applied in order to investigate the discussion, and as well as several recommendations that I propose. So before we start the presentation, I would like to say that businesses and governments rely on infrastructure, platform software, and anything as a service more and more. Now, as a result of governments as well as businesses getting these service offerings, we are starting to see and we're starting to witness more cloud computing data breaches. They're also increasing in frequency, so we are seeing them more frequently now compared to prior, as well as its size. Now, an important aspect of this research is that service level agreements are more towards the business side. So they are typically agreements between the cloud customer as well as cloud provider and the cloud customer. However, they don't typically include the end user and their needs. So fundamentally, the research question is, what kind of recourse does a consumer have when the personal information has been disclosed, even if a hacker never intends to use that data for fraudulent purposes? So in order to investigate cloud data breaches, it's also important to have an overview of the cloud computing value chain. So in this study, we have applied 4 stakeholders: the cloud provider, cloud customer, the end users, and the courts. They are essential stakeholders in investigating cloud data breaches. In identifying the vulnerability of a cloud service, it's important to factor in that the human is not the only weakness. We also have to factor the technology. Or in many circumstances, it can be a hybrid vulnerability, which includes both the human risk factor as well as the technology risk factor. Now, in understanding the risk behind a cloud data breach, it may not be known until days, weeks, or even months later. And regarding to reporting, database implications are becoming more common in many jurisdictions, and they are critical in notifying end users. The literature review saw a substantial amount of studies that investigating transnational organizations that were impacted by data breaches. As a result of an increased number of online services, inadequate security, and stronger regulation, we are starting to see these data breaches come to light and also being front page news. Now, there are a number of data breaches that have specific types of data that was disclosed, including personal identifiable information, financial, health, genetic, and geolocation data. These database examples include the 2021 Airtel, 2017 Equifax, and 2014 Yahoo data breaches. But historic data breaches, such as the 2009 Heartland data breach, is an important data breach that is constantly being investigated, and as a result of these data breaches being investigated time and time again, we are starting to see the consequences and the lessons learned. So, in essence, historic data breaches as well as current data breaches are often enable us to retell the story of that data breach event. The methodology applied in this study was using a case study method, and there was 3 specific cloud computing data breaches that were chosen, and they are the 2011 Sony PlayStation Network, the 2014 eBay, and a 2014 Yahoo data breach. We applied case law study to investigate the social technical implications of these data breaches. Case law brings key legal issues to the surface, and they provide an analysis of judicial decisions that otherwise were not reported in other types of data, including news or trade. So case notes offer unique characteristics, such as procedural history and case summaries. We use the Westlaw International and LexisNexis research databases in order to extract and collect case notes. We applied a three-step process in data collection, and they are: one, identifying the search terms that were applied to those databases to extract the case notes. We applied specific dates or search dates that gave us a point in time in order to extract those case notes from. And we also identified the jurisdiction, such as the US, including state and federal data breach cases. Now, we also applied a qualitative data analysis approach, where each case study was dedicated its own space, and each case study contained a brief summary. Now, we conducted a strict process of identifying the main plaintiffs in their allegations towards their disclosed data, as well as the defendant's position and the court's outcome, if applicable, within the case notes. So we first start off investigating the 2008 Sony PlayStation Network data breach. The Sony PlayStation data breach affected more than 100 million users globally, which had their PII and financial information disclosed. Immediate class actions were filed against Sony as a result of that data breach. Plaintiffs, in this circumstance end users, immediately filed identity theft claims as well as misuse of data allegations. However, it was come to no surprise that the defendant, Sony, in this circumstance, claimed identity theft was purely speculative. It denied any wrongdoings in the way that it managed its corporate cloud network. Plaintiffs applied ruling in other data breach cases, such as Krotner versus Starbucks, in that personal data that was disclosed but not used could still be subject to injury in fact. The 2014 eBay data breach impacted more than 145 million users globally, as well as had their disclosed PII, including usernames, addresses, phone numbers, and passwords. As was witnessed in case one, eBay also delayed notification to its end users by more than 2 months. In the one case note that was investigated and analysed, Green versus eBay 2015, the court dismissed the plaintiff's allegation on data misuse and identity theft claims. Alternatively, one case note, Adobe Systems privacy litigation, the court granted data misuse allegations. Now, this was quite a fascinating outcome in that the two data breaches shared common characteristics. However, jurisdictions played a role in this. So therefore, in Adobe plaintiffs, refocusing allegations on imminent or future harm were granted, as opposed to green versus eBay. The more recent reporting, the Yahoo data breach impacted 500 million end users. However, the actual data breach occurred 2 years prior. Negative sentiment on the social implications of the Yahoo data breach, as well as other data breaches that were in the analysis, saw that plaintiffs were denied most, if not all, identity theft allegations, as well as data misuse claims. In the Yahoo customer security data breach litigation, the plaintiffs alleged their data was also at risk of misuse. However, other case notes focused on end user data misuse imminently rather than speculative. So what we learned from these 3 data breach case studies is that there is an increase present in plaintiffs and users in this circumstance claiming misuse of data aggregation. We also saw that inability for end user compensation. So in this circumstance, the case studies were over a 2-year period, and many of these court outcomes were not resolved within that period. Therefore, the slow and tedious US court system process, providing real risk almost impossible. We also saw that past outcomes serve the purpose of knowledge in how data breach case law is achieved. There is a growing trend for end users joining class actions. The 2014 Yahoo data breach had a substantial amount of other case notes stating that class actions and merging and joining of those class actions to be something to be considered. So in essence, there are 2 recommendations or 2 stakeholder types recommendation based. So our first recommendation for cloud providers and customers is to implement risk management strategies. So throughout these case studies, we saw that corporations, i.e. cloud customers, lacked any risk management strategies, if they had any at all. It's also important to review service level agreements, incorporating end user needs as well. Proactive social technical approaches, considering the design, development, and implementation of risk strategies. And finally, enhanced training and education programs for employees. As we stated at the beginning of the presentation, technology isn't the only risk factor that corporations should be focusing on. Therefore, the human, the user of the cloud system, needs to be trained and it needs to be further educated to avoid any or to mitigate social engineering attacks. Now, our second recommendation group for end users, consumers, as well as citizens, is to raise awareness of high-profile data breaches. We have seen on front page news every single day data breaches that impact a large portion of our population, either nationally or internationally. We need to advocate and lobby for stronger data protection laws. We have seen progress in the EU with the General Data Protection Regulation. However, elsewhere, there's been minimal, if not no progress in data protection, as well as imposing or implementing, rather than a state level mandatory data breach notifications, but to focus on a federal level, having one unified reporting approach that captures the majority, if not all, industry segments. So, in essence, the research has fulfilled the research question. The first outcome of the study was that since 2007, cloud services have been on the rise, but simultaneously they have exposed some of the most respected businesses. We have seen it in these three case studies that Sony, eBay, and Yahoo, which are national as well as transnational organizations, they have too fallen victim to cybercrime. The second main outcome of the research indicated that cloud providers and cloud customers are not being held accountable. We are also seeing that cloud providers are not even in the legal context or in the legal settings. And it's often between the cloud customer as well as the end user. End users are constantly alleging that their data could be sold on the dark web. And despite repeated attempts, end users are continuing to pursue the path of class actions to demonstrate their risk of their data being misused. However, there's been little progress in this area. Finally, I would like to conclude the study, the presentation, in stating that these case studies not only show the complex nature of data breaches, but it shows the connectiveness between some of the most well-known organizations as well as end users globally. Thank you.
Thanks so much, David. It's always great to get your insights. And I know that people listening to this presentation will really appreciate the level of depth you've gone to with respect to the case studies. I mean, you've heard about Sony, eBay, and Yahoo. And as we know, there's like hundreds more. It's amazing to visit now websites and online, security journals, top 50 hacks of the year.
Yes.
They don't seem to be stemming, they just seem to be getting bigger.
Yeah, they are getting, there are continuous data breaches that affect or impact a large portion of the population. Like we are seeing, data breaches have over 100, 200, 300 million people, more than the population of the US. Like we saw in the 2014 Yahoo breach, impacting 500 million end users. So these are 500 million end users located globally that had their information disclosed that could be used for fraudulent purposes.
Took them 2 years to tell everybody, right?
As well, yeah.
And the thing is, I mean, this is something that comes up in your review of literature and also what we're seeing online. People are still reusing their passwords between applications. So if Yahoo was your preferred email client or search engine, you'd log in every morning and then you use the same password for other applications online, the risks are high.
Yes, yeah. One of my research outcomes in my thesis was I basically portrayed a risk profile in how one user over a period of time could be using several, if not many, online services with the same username, or like in most circumstances, it's just an email address, as well as the same password. So they're not only susceptible to that online service, but as well as to the countless of other online services that user is using. So the risk appetite in this circumstance is much greater than I'll say, like in previous technologies, I would say.
Yeah, like imagine taking that scenario a bit further. Okay, 500 million people have had their data disclosed. Well, those 500 million people might use on average like 10 different applications, maybe 50 applications, who knows? And they're using the same password or similar passwords for all of those. So it's all of a sudden 500 million times the number of apps that use the same password,
Yes,
at least.
that's right. And also we have to, consider that authentication technology is also changing too. So we are witnessing more and more applications starting to use biometric data to also authenticate end users, which I highly regard as an effective strategy, but also simultaneously it will increase the risk for end users. Like you have many devices now that they claim that biometric data is stored at the device level. I agree to disagree in that. Yeah.
So let's talk about that a bit, because biometric data, health data, it's called sensitive data, right? And sensitive data is not just like your personally identifiable information, like your name or date of birth, where you live, your street address, but it's highly sensitive because it might infer something about you, your status. But what did you find with respect to sensitive data? You mentioned in one of the case studies that financial data had also been taken. Was that the Sony?
Well, the Sony data breach, yes.
Yeah. Tell us what people said in that breach again. Like, they said, yes, our PII was taken, but what else? Sensitive data, and what played out there?
Well, we are starting to recognize that data breaches that only have end user PII disclosed doesn't necessarily mean that they are not susceptible to financial fraud. So while financial information might have not been disclosed in the eBay as well as the Yahoo data breach, the Sony data breach was particularly important because it involved two types of data sets that could have been used for identity theft on those end users. So in essence, I would say that financial information is important to safeguard, but at the same time, it's much easier to change that type of information compared to PII, as well as genetic and healthcare information.
Interesting perspective. And this time lapse, that you keep seeing recurring between the time of the data breach, the business recognizing that it's had its systems penetrated, and a disclosure, at least or not disclosure, notification to the consumer. What are you finding? Is there a pattern there? Are companies getting better at informing their end users that they've been hacked? What are you seeing?
So there definitely has been an improvement to some regards. However, there hasn't been a substantial improvement. So as these three cases have demonstrated, there was a time lapse between the actual data breach as well as a notification to those end users. In most circumstances, the first type of notification in those three data breaches was actually the media. The media reported those data breaches. So in these three data breaches, the organization responded to those media reports. Now, there were pre-2018, considering the EU did roll out its new regulation, the data protection regulation. So that, even though, well, this research study didn't focus on that, I would say that progress since these three data breaches, there has been improvement in data protection laws. Substantial, I would say yes, but that would only be in particular jurisdictions.
And this wave of mandatory data breach notification laws now, do you see it as a strength? It's helping, or it's not really doing anything different than the old ways?
Mandatory data breach notification laws, I would say that it is working. It is working, but more needs to be done. At the moment, organizations are being held accountable to a certain degree, but I would like executives or management to be held more accountable in certain data breach cases.
I'm saying, like, I just rattle off. I mean, the traditional ones are the cases that have played out in the courts, those data breach events. You know, you studied two of these big ones, or sorry, three of these, the Sony, the Yahoo, and the eBay. But we can go back to TK Maxx, we can go back to Heartland in 2009, Dropbox in 2012, Tumblr in 2013. But when you look at the scale of the ones today and the scope, as you said, a lot of these companies work transnationally, and they operate transnationally. They've got consumers and end users all over the world, subscribers to their content and their services. But Adobe Systems this year, 152 million records. Airtel, 2021, 320 million records. Animal Jam last year, 46 million records. And it keeps going down. No one's immune. Anthem, AOL, Capital One, Check People, Elasticsearch, Equifax, Facebook. Facebook in 2019 had 540 million records taken, and then a second data breach consecutive, not far from that one, was 267 million records, and it wasn't a hack. In that case, it was poor security. So you can sort of say somebody or an entity penetrated the systems, but they didn't put it down to a hacking or an insider attack or something that was unsecured or an unknown cause. They put it down to poor security. So how can we look at these data breaches, especially when it's about poor security? Even TikTok last year, 42 million records due to poor security, not a hack. What do we do about that when organizations like Facebook, suffer poor security? It's not even an insider attack. What do we do? How do we respond? What do we say to these companies? Like, you've got the majority of the world, linked to you. What pressure can you apply? What's the way?
We are starting to see a lot more security executives which have technical knowledge or a technical background at an executive level. However, those positions are not being fulfilled by all organizations. We did see in the 2011 Sony data breach, and this was one of the first major data breaches that in a security executive position, so Chief Information Security Officer, was actually created post data breach. And that was to bridge the gap between security as well as the human factor in one. So we can say there has been improvement in that regard. It's just been a very slow and tedious movement forward.
Now, when there is a cloud provider involved in this process, businesses whose core competency is not information technology or building software, they're going to outsource, and they'll outsource to one of the big giant cloud providers, of which there are about 5 to 10. Depends how you want to count them, but the majority of the market share is held by 5 to 10 of the biggest players in the world. And if you look at the top 4 or 5, they've got a big chunk of the market per se, the majority, I would say, but they're never in the news. When there is a data breach, it's the business that suffers. That front interfacing sort of identity, like whether it's Facebook or Airtel or Capital One or Uber, whoever suffered the hack or the breach. How or where do cloud providers fit in this scenario? Like, how come this is a phenomena that we see time and time again?
That's a reoccurring nature of the beast, I would say, and that clearly shows the complexity of a cloud ecosystem. We have many players in the game. Now, being held accountable, I would say, first and foremost, is the most important thing. However, little has been done in that area. Like in 2019, the Capital One data breach was a perfect example of this, where Amazon Web Services, was a cloud provider in this situation, and we saw little or no repercussions for the provider. So, and Capital One obviously suffered brand damage and reputation loss. However, AWS was walked scot-free. But it just shows the complex nature of how these systems run. So you don't only have cloud providers, you've got third-party providers that also input data as well as extract data. And they too haven't been, like they haven't been taken to court, or they haven't been on front page news. So there is a constant pattern between the cloud customer or the organization that is providing the online service as well as the end user. So that link is defined. However, the other relationships surrounding the authorization of that service is it's not really
It's fascinating because whenever a cloud provider goes into business with a client, a business customer, a government agency customer, there is this thing that you mentioned, the service level agreement, the SLA, that has to be written. It's a contract. There are metrics identified where if there is some kind of interruption, penalties apply. If there's an outage, if things are not available, either side gets somehow compensated. But there's no compensation, or very limited, if any, for the individual end user. And they're not engaged in this service level agreement. The service level agreement is a contract between two entities, two organizations, two agencies, two businesses. And the service level agreement doesn't really address end users apart from being a metric, if that. If people are trying to, for example, log on to a software client online to buy something, do a transaction, and they can't, well, the business customer will request some remuneration from the cloud provider because their end user, their subscriber, is not really having access to a service that's been paid for in some kind of usage capacity. But there is no room in the SLA for the end user. So if something is disclosed or misused, they can't prove it. Tell us about terms like disclosure, about misuse of data, about identity theft or identity fraud. All of these words played out in the court, but every single time we heard again and again, but it's not enough. To speculate is not enough, as you said in your presentation. Where does that leave us?
We have to look at our laws. We have to look at, we have to look at several different factors. I would say that looking at data protection from a consumer perspective, and really looking at the long-term consequences of the data being disclosed. and a type of data that is disclosed, such as username and passwords, that could be easily changed, as opposed to sensitive information that is specific to the end user, which holds unique values to that individual. So when it comes down to identity theft, I would say identity theft is a long-term issue, but it's something that cannot be measured per se. And it's very difficult to establish the link between the disclosure and the identity fraud attempt. So whether the hacker or some other individual opening up a bank account, getting a line of credit, etc. So these are specific terms or specific outcomes from these case notes that are reoccurring time and time again. So as I said earlier, accountability at the moment is done at an organizational level. I strongly think in order to progress the movement in consumer law regarding data breach disclosures, more accountability needs to be done at an individual level.
Do you think consumers will ever have true visibility of the misuse of their data in the case of a data breach? Can we even put a cost on that?
There are many studies out there that try and identify the tangible costs of a data breach, X amount per record, X amount per, 1,000 records, etc. But those only try and identify the cost at that specific time. So for example, let's say Yahoo had 500 million end users, data disclosed at $30 per, credit monitoring fees. You can assign a specific tangible cost to that. However, you cannot assign a cost to a record that is no longer in possession from that company. Assigning cost to a record that's been disclosed is highly unlikely.
As a final point, I wanted to ask you about the power of class action lawsuits, especially consumer class actions. Do they work? Is it worth the trouble? Is it worth the litigation in the courts over so many years? What is it? What's that mechanism do for the consumer, if anything?
The US court system is very slow and tedious, as we've witnessed in the case studies. Class actions are starting to become very popular, especially consolidation of class actions in numerous states and territories. Whether there has been whether there's progress by going down that route, I will say yes, but once again, it's a very slow and tedious process. It actually drains the plaintiff in many circumstances, not only emotionally but also financially. A lot of class actions are often steered by one or two individuals that try and push the case forward. And when you have other stakeholders that are involved, too, that are often not represented as much. I would like to see other specific stakeholders being involved in class actions as well. So not only security experts, also privacy advocates, etc.
Well, I just want to say congrats on getting this paper through in the IEEE 21st Century Wiener Conference. It's the third one. This year it was held in Chennai, India. About 75 papers were submitted for review. Less than a third got in, which shows the kind of conference it was. Congratulations again on graduating last week. I think I cited your testama, even though most Aussies are in lockdown at the moment.
Yes.
10 years of an awesome journey, and we've had the pleasure of witnessing your growth as a researcher and practitioner. You're from industry, have been throughout the whole process, and we're fortunate and we can't wait to continue collaborating with you on this very important topic of cloud computing, and who knows, it might morph into our work into big data and governance and how all of this interplays together. But congrats on the multiple outcomes coming through.
Thank you. Thank you very much, Katina.
Thanks, David. Thank you again.
Nice. All right. Bye.
Bye.